you. Joining us now to discuss a bit further, criminal defense attorney Eric Schwartzreich is joining us. Also, criminal defense attorney, trial lawyer Nicole DeBoard. Thanks to both of you. So much is riding on this particular trial that we're watching, this federal trial. What exactly do the states, Eric, have to prove to win this case?
So their burden of proof is preponderance of the evidence, just 0.1%, and it's more likely than not. And what they're claiming to get around the Communication Decency Act, the statute 230, which would give immunity to Facebook for anything that was posted by a user. But how they're framing this, because how everything is framed or anything framed in a case is very important. They are saying that is a product design issue, that there's a defect, that there's a flaw, that Facebook, Meta was aware of the dangers. They were aware of this product to children and the exposure, likes, and the algorithms. And the way they designed it is deceptive. And they are not covered under that act. And Meta's going to say, listen, we have protection under the Communication Decency Act, and they can't prove this. Duty, breach, causation, damages. Where is the causation? When you talk about the tobacco cases, showing that what was done here even caused, any injuries or mental health, and that is a hurdle that has to be overcome.
What they knew when that, evidence to that or that speaks to that has already been presented. Nicole, will that be the most important element of the case to prove that they knew that there was damage being done to teenagers and really didn't raise the red flag?
Exactly. I think that's exactly where the trial will focus. And ultimately, the jurors are going to have to decide whether the evidence presented rises to that level. To me, the most compelling part of the plaintiff's case in this whole presentation has been the efforts that appear to have been put in place to make social media platforms addicting to very young people. And the fact that that was their target audience and that they wanted to keep them engaged. And that they had built algorithms to make sure that that would happen. And I think that it's very possible that jurors will find that somewhat disturbing.
Eric, if Meta loses, what could the judge realistically order the company to change?
I mean, the impact is huge. Not only the financial impact, because there could be up to 1.4 trillion, if not more, in damages, but what could be ordered to be changed, how information is collected when there's a 13-year-old that signs online, because also part of this is information that Facebook is gathering and collecting on minors. So they can order them to change the information that's collected on minors, and they can order them to, these scrolling, infinite scrolling, these likes, to not engage in their product or design it in a way which be enticing to minors.
Sure, the stickiness of it, right? Before I move off this topic and jump to our next topic, I want to ask about this jury-judge relationship, because I know the judge decides, but there is a jury hearing the case as well. How do they communicate, Nicole? And what is he taking advice from the jury? How does this work?
Ultimately, the jury is the judge of the facts. What do they believe and what do they not believe? And the judge is the judge of the law. And so that is how this is divided out in this circumstance. It is a symbiotic relationship. It's ultimately the court has the ability to make decisions about the law, but the jurors will decide what they find to be credible.
Interesting. We're watching it closely. Meanwhile, also looking at this Karmelo Anthony case. He's back in court actually today. He's asking for a new trial. He wants a new judge. Of course, he was convicted of stabbing and killing a 17-year-old high school athlete at a track meet and then sentenced to 35 years in prison. His attorneys are arguing that the judge had overly strict courtroom rules and gave incomplete jury instructions. Does that get a new trial, Eric? Is that grounds to get a new trial?
So getting a new trial in the trial court, it is a difficult hurdle. Judges don't usually grant them. But the fact that there was also a motion to recuse the judge, the fact that the new defense attorney got some headway with that, and we have a new judge based upon the appearance of impropriety or the comments that the judge supposedly made to the media, that helps, because now you have another judge. You're not asking the same judge to say, hey, you made a mistake, some error that is not just harmless error, but there's an error here, and they're going to review it. I think there are some compelling issues to consider before it goes to an appellate court, as far as the jury instruction or whether the self-defense instruction was confusing in and of itself, as far as jury issues with the Batson challenge and how the jury voir dire was handled. But the reality is these trials are rarely granted in the trial court and probably in an appellate court. But I think that they definitely are in a better position, the defense, based upon the judge's recusal today.
Okay. The new judge is assigned for Thursday's hearing. We'll be watching that very closely, see where it heads. Meanwhile, to Lindsay Clancy now, this has just been heartbreaking to watch. Prosecutors arrested on Monday, actually, and they said that Clancy had planned the murders of her 3 children before faking her suicide attempt. Those were their words. The defense called Clancy's own mom to the stand to testify. Listen to this.
Lindsay was a very loving mother. She was dedicated to her children. She was a fun mother. She was always doing things for her kids. She always wanted to be a mother, have many children, and I felt it was the best thing that ever happened to her. And she would do anything for her children. She was just a loving mother.
So that was her mom. Then her mother-in-law, Susan Clancy, was also describing Lindsay as begging for help in the run-up to the murders. What kind of impact does that have on the jury, that both mom and mother-in-law were advocating for this mom?
You know, I think that this is just the worst of the tragedies that you could possibly have in a courtroom. And that's going to be the biggest battle really on both sides. But having the parents for Lindsay come in, or the mothers, the mother-in-law and the mother come in and testify on her behalf, I think really personalizes her, gives the jurors a peek into what her life was like before this. And it humanizes her. And, you know, the prosecution is painting her as this conniving, manipulative person who would fake her own, suicide attempt. Whereas you have human beings who actually loved and interacted with her prior to all of this and prior to this terrible day. And so I think it's very, very meaningful and potentially quite compelling.
Eric, if you were defending her and making your case to the jury in closing, what single fact would you drill down on to really try to get the jury to understand, you know, that she wasn't clear on what she was doing?
You know, similar to the way judges don't like granting motions for new trial, jurors typically are not fans of sanity type of defenses, especially when 3 children are killed. But the defense in this case has done a masterful job, and the burden of proof here, it has been on the prosecution. And what's interesting in this case is the voice command. The defense has put on some evidence during cross-examination, and I believe witnesses, that she heard voices. And what's different here in Massachusetts than most other states, you don't have the McNaughton rule. It's not just that she appreciated the consequences of her actions, but did she know right from wrong, and was she able to conform to that substantially? And it is an easier hurdle for the defense, and I think I would argue if I were the defense attorney, because I don't want to critique what he's doing, because seeing insanity defenses, this is one of the best I've ever seen.
Yep.
I would just argue and apply the Massachusetts law, which was the voices that she heard, the family members. She was crying for help. She was on the medication. No one was helping her, and she couldn't appreciate, you know, what she was doing, and she couldn't conform, you know, to the law. And I think that there's a chance here, but again, I think it's a very difficult hurdle in the case. 3 children.
Yeah, three kids gone. Nicole, I know you're a defense attorney. If you had a prosecutor hat on, what would you drive to the jury in closing to make your case? I know they're facing major headwinds. Admonished yesterday in court, stubbed their toe. They're up against it.
Yeah, I mean, this to me is a really difficult case for the prosecution to sell, really for a variety of reasons. But if I were trying to do that, which I don't know that I would be, my effort would be to show that she clearly planned this out in terms of having the husband exit the home and have some time, which indicated that she knew that what she was about to do was wrong because she planned it.
Eric,
I
Nicole.
think.
Oh, please.
So I think that's a small toehold in a very difficult case for the prosecution.
It's been very difficult to watch. Eric, Nicole, appreciate both of you and your expertise. Good to see you.